The H1B Guy here, and today I'm going to break down equal access for green cards for legal employment, Eagle Act of 2021, also known as HR 3648. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. Today's post is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads and local job board postings since 2001, and also by Path to Canada. Path to Canada provides an ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Path to Canada is your answer. Well, as I covered on the H1B Guy news for the week ending June 4th, 2021, U.S. Representatives Zoe Lofgren and John Curtis introduced HR 3648, Equal Access to Green Cards for Legal Employment, Eagle Act of 2021. Included in the press release on Lofgren.gov was a link to a section-by-section breakdown titled Equal Access to Green Cards for Legal Employment Eagle Act of 2021, section by section. I'm going to use the text from this document and add my thoughts on this proposed legislation. Starting with Section 2, Numerical Limitation to any single foreign state, eliminates per country limitation on employment-based immigrant visas and raises it from 7% to 15% for family-based immigrant visas. Provides a 9-year transition period for the elimination of the per-country limit for employment-based second, EB2 advanced degree professionals, exceptionability aliens, and employment-based third, EB3 professional skilled workers, other worker preference categories as follows. Reserve visas for lower admission states, reserve visas for countries other than the two countries with highest demand for such visas, India and China, for 9 fiscal years as follows. Fiscal year 1, 30% of such visas. Fiscal year 2, 25% of such visas. Fiscal year 3, 20% of such visas. Fiscal year 4, 15% of such visas. Fiscal years 5 and 6, 10% of such visas, and fiscal year 7, 8, and 9, 5% of such visas. Reserve visas for new arrivals for fiscal year 1 through fiscal year 9 reserves an additional 5.75% of such visas for individuals from countries other than India and China. Reserve visas for shortage occupations. For fiscal years 1 through fiscal year 7, reserves 4,400 EB3 visas for individuals who will work in a shortage occupation, nurses, and physical therapists. And then additional parameters for fiscal years 1 through fiscal year 9. No country may receive more than 25% of reserved visas, and no country may receive more than 85% of unreserved visas. This bill also includes a safety provision to prevent visas from going unused during the 9-year period. Well, this language and approach to eliminating the green card backlog that has been caused by the 7% country cap for employment-based preferences should look familiar. It is very similar to the language that served as one of the key pillars to the Fairness for High-Skilled Immigrants Act, HR 1044. The tiered approach of decreasing the rest of the world's allotment over 9 years by 5% increments for the first 6 years, 10%, and then 5% for the last 3 was hotly debated in its previous form, and I expect this will be no different. However, it continues to appear to be the most popular approach to clearing the green card backlog while attempting to minimize the impact as it works through each year. I do really like the proposal of setting aside EB3 visas for shortage occupations, highlighting both nurses and physical therapists. Both occupations have proved to be critical necessities as the U.S. has battled through the COVID-19 pandemic. The last point for this section is the provision which prevents visas from going unused. Putting an emphasis on maximizing number usage is an extremely important aspect of eliminating the current backlog. Moving on to Section 3, posting available positions through the Department of Labor requires employers to provide public notice of new H1B positions on a Department of Labor DOL searchable website for at least 30 days. Employers are not required to post positions that will be filled by individuals who are currently in H1B status and have already been counted against the numerical limitations or are authorized to accept new employment upon the filing of an H1B petition by a prospective employer. Online job postings must include the occupational classification, job title, education and experience requirements, salary or wage range, benefits offered, and location, and the employer's process for applying for a position. I'll say this, the more transparency, the better for new H1B visas, especially with the new electronic filing process for the H1B lottery that's been used for fiscal year 2020 and fiscal year 2021. This also helps to bring clarity around the recruitment process of the open position in its entirety. Again, the more awareness, the better. But as a reminder, this only applies to new H-1B visas, not continuing employment. Continuing with Section 4, H-1B employer application requirements. Prevailing wage requires employers to submit to DOL documentation of the methodology used to establish the prevailing wage for a prospective H-1B employee. New labor condition application, LCA, attestations requires H-1B employers to attest that advertisements for the position do not state that the position is only open to H-1B workers so that H-1B workers will be given preference. The employer has not primarily recruited H-1B workers. If the employer has 50 or more employees in the United States, not more than 50% of the employer's U.S. workforce consists of H-1B or L-1 non-immigrants. LCA fees requires the DOL to establish an administrative processing fee for LCAs, and then the elimination of B1 in lieu of H1 prohibits the Department of State from issuing B1 visitor visas to individuals seeking to perform H1 services where the source of remuneration or salary comes from a foreign employer. This section places reform around the H-1B visa in terms of the LCA attestations, and then also gets into specifically limiting the candidate pool to only H-1B visa employees, as well as discussing the 50-50 rule, which I've previously covered. The 50-50 rule restrictions are put on employers from obtaining new H-1B or L-1 visas if their current workforce exceeded 50% or more H-1B and L-1 visa holders. This language was added to S-386 as part of the unanimous consent negotiations surrounding S-386 back in 2020. Adding an administrative processing fee to LCAs will only increase revenues for the Department of Justice, as employers will continue to have the need to submit LCAs for certification. It's just not going to go anywhere. Lastly, eliminating the B1 gray area for individuals and employers is another critical step in enforcing these overstays that we've seen historically over the last several years. Continuing with Section 5, investigation and disposition of complaints against H-1B employers expands whistleblower protections to preclude employers from taking, failing to take, or threatening to take or fail to take a personal action against a whistleblower. So here's another carryover from the amendments that were added to S-386. This is what bipartisan reform looks like. Attempt to fix the green card backlog while also reforming the H-1B visa. In this case, adding protection to H-1B visa employees. Moving on to Section 6, labor condition applications. Public examination of LCAs requires DOL to publish lists of LCAs filed on its website. Prevailing wage certifications ensures that prevailing wage relates to substantially similar employees with a geographical area and is based on the best available information for the area within normal commuting distance of the place of employment. Audits allows DOL to survey employers for LCA compliance and conduct compliance audits of any H-1B employer. Requires annual compliance audits audits of employers with more than 100 full-time employees if more than 15% are H-1B non-immigrants. Requires DOL to publish results of required annual compliance audits. Any audited company cannot be re-audited for 4 years unless there was a willful failure to comply with the program requirements or if there is evidence of misrepresentation or fraud. Investigations eases the process for investigating LCA abuses by allowing investigations to commence based on credible information from an anonymous source and striking a provision that says officers or employees of DOL cannot report LCA violations. Striking the provision that prohibits investigations unless there's a reasonable cause to believe the employer willfully engaged in LCA abuses or a pattern of violations. Performance data on DOL.gov is already happening, but it is reported quarterly and not in real time, meaning that you can access the previous quarter for fiscal year's data. Something tells me that we're going to see amendments or some kind of language added to the prevailing wage determinations. I honestly also believe that we're going to see a significant increase in audits that will begin sometime in fiscal year 2022. This language will give the DOL the authority to do so, including those tips that are received anonymously. And then wrapping up with Section 7, Adjustment of Status for Employment-Based Immigrants, amends the Immigration and Nationality Act, INA, by adding a new Section 245N to allow most non-immigrants and their dependents who are the beneficiaries of an employment-based petition that has been approved for 2 years to file an application for adjustment of status, even if the immigrant visa is not immediately available. Children remain eligible for adjustment of status regardless of their age or if the principal applicant is deceased at the time a visa becomes available. Travel authorization, principal applicants and dependents are eligible for advanced parole while the application is pending. Employment authorization, principal applicants are eligible for work authorization subject to conditions and special filing procedures described below. Dependents are eligible for work authorization if they were authorized to work or were in a status that allowed them to request such authorization at the time the adjustment application is filed. Fees authorizes the Secretary of Homeland Security to collect $2,000 fee in connection with each Form I-485 Supplement J filed in connection with an application for adjustment of status under this section. Effective dates. The ability to file for adjustment of status under this section takes effect 1 year after the date of the enactment of the act and sunsets on the date that is 9 years after the date of the enactment. Applications that are filed prior to the sunset date are grandfathered. So this would just be a huge change, really making anyone who has an I-140 that's been approved for 24 months eligible for an employment authorization document, EAD, with advanced parole, AP rights, granting protections to their dependents. I think the biggest point, though, is that this is for employment-based preferences. So once individuals have an EAD with AP, they'd be given freedom of travel and employment with a few stipulations on job portability that would be required. However, this would not protect those documented dreamers that are dependents of E-2 visas, as they do not fall under employment-based sponsorship. HR3648 proposes a fee for I-485J that would come to $2,000 per application if this were to become law because of the increase in filings that they would see. That should definitely help pay for a few more certifying officer salaries to process the available annual visa numbers. Wrapping up, the actual phased approach would actually come to 10 years, taking effect 1 year from the date of the enactment, then working back in 5% increments periodically over the next 9 years. All in all, some familiar language and some new text are both proposed in HR 3648. As I've said, I honestly believe this piece of legislation reform has the best chance to reform our immigration laws and see passage in the next 18 months. In the meantime, I'm going to wait patiently to see who's going to be the named sponsor in the Senate and if that will include bipartisan co-sponsorship, just as HR3648 has. For the full post on equal access to green cards for legal employment, Eagle Act of 2021, otherwise known as HR 3648 breakdown, please check out the H1BGuy.com. And a reminder that today's post was brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad regardless of which city you choose. RecruiterNetworks.com has been the #1 place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the perm advertisement rules. RecruiterNetworks.com. Tell them the H1B guy sent you. And this post is also brought to you by Path to Canada. Path to Canada provides an ideal plan B for high-skilled immigrants currently located in the U.S. whose status may be uncertain. If you're facing an H1B denial or OPT expiration, don't get caught off guard. Make sure you have a plan B, and Path to Canada is your answer. They will help you navigate the process. If you're interested in finding out more, please be sure to click the link in the video description below. Just wanted to ask you again to please like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so that you're notified anytime we post new content here to this channel. If you've made it this far, I just want to say thank you for taking the time to watch my video. I really appreciate your support. The H1B Guy, your global source for all things H1B.